So once again, think about your case. It used to be that the VA, they've got some really tough rules now, and they are very, very hard on filing dates. So I'm finding that even with unemployability, people used to file a claim, they would get 70% for PTSD, and then they would file the claim for unemployability. And the VA would normally go back to when the 70%, if they're going to grant unemployability, which is the inability to work, they would grant it as of the date that the 70% for PTSD was given. They're not doing that anymore. I'm finding over and over again, they're saying, well, you haven't filed a claim for unemployability, so we're going to go with the date that you filed it. So they're not doing
That's
that
why
anymore.
I'm
finding over and over again all the problems they have and file them right away. Now, if you are denied all of the things, say you ask for, I would not appeal the unemployability up to the board until you actually have a rating that would allow them to grant you unemployability, because they won't do that. This is another new thing. Before they would remand the unemployability back to the regional office in order to see if you're granted the PTSD or you're granted the diabetes. They're not doing that now. What they're doing is they're denying you at the board and saying at the time you filed the appeal, you did not have a 60% or 70% rating, which qualified you for unemployability. So you need to start processing your claims in a different way. And so I just hope to give you a little bit of insight into how you should do that. I'm going to pull up the questions we have today, and I'm going to start with Noah's question. He says, if a VSO is handling new claims and an increase request, do they have to handle higher level reviews as well, or can that be handled separately? Also, do new claims and higher level reviews all go to the same location, Wisconsin? I'm really not quite sure what you're asking, Noah. If you have a VSO, yes, they can handle everything that you have, okay? And no, the claims don't always go to the same place. We now have a system where what the VA is trying to do is look at parts of the country that are not as overwhelmed with claims, and they are shipping cases all over the country. Because they're electronic, that's not a problem. So say you live in Wisconsin, there's no reason that your case is going to be decided in Wisconsin. It's going to be decided wherever the VA says there's an ability to handle your case quicker. I actually see that sometimes cases are sent to California and New York, and then back to Boston, and then all over the place before they're actually handled. So no, there's no way of knowing where your case goes. And just because somebody in Wisconsin or Boston handle one, doesn't mean that that same person's going to handle the others. They continue to move around to where they think there's the best ability to get to them the quickest. Willie. Yes. Okay. So I can just go down here, live chat. Okay, Jessica Parker. Which SMC should you expect for PTSD at 70% or 100%? Sleep apnea, migraine, eczema, diabetes, neurological, tinnitus, chronic fatigue. I'm currently at SMCS. Okay, so Jessica, what I think you're saying is that you have been found service-connected for PTSD at 70% or 100% SMCS. Okay. Sleep apnea 50, migraines 50, eczema 60, diabetes 20, neurological 10, and tinnitus 10, chronic fatigue 40. Okay, so SMC is when you get more, so you're at 100%. So SMC is when you get more than 100%. And one of the first SMC steps that you can get is S. And that means that you have 100% for one or more issues, like it could be the PTSD. And then you have at least a 60% of combined ratings for other things. And that's what you have right now. But it seems to me that you should be filing for, I would wonder if, first of all, if there's any headaches to go with. Let's see, you already have the headaches. Aid and attendance was something I'd really be curious about. Aid and attendance, so SMCS gives you $300 to $500 more than the 100%. If you need aid and attendance, that's going to get you more up into the $4,000 range each month. Now, aid in attendance is for someone who cannot do some of the daily activities because of service-connected problems. For instance, if you have PTSD, perhaps you can't remember your medication, or perhaps you forget your doctor's appointments. If you have headaches, maybe you can't do anything and you need somebody to bring food in for you or help you with getting your medicines. So you need to think about the things that you know you can't do now that you used to be able to do. And if you have a number of them, I think that you should file for aid and attendance, okay? But that's the SMC that I think that you might be able to obtain. The neurological, you're only at 10%, but if the neurological becomes, and I'm assuming this is peripheral neuropathy because of the diabetes, if that comes to the point where you have difficulty walking or using your hands, then that's the loss of use of hands or feet. And that can get you much higher up in the SMC claim. Mr. and Mrs. Olsey, I'm 100% permanent and total for PTSD with traumatic brain injuries as a symptom, but I have different symptoms for both disabilities and different events that brought both disabilities. What process should I take to separate them? You're going to need an expert who says that they are separate and distinct, and they should do a thorough evaluation of you. One of the problems with traumatic brain injury, for instance, is the VA does not give a complete evaluation. When they send you for a compensation and pension exam, what they're doing is they're doing a screening, which is a very brief evaluation of TBI, and it is not very thorough. So if you can pay someone to do a complete review of TBI and then do a report that shows the difference between the two, the TBI problems and the PTSD, that should help you get a rating for both because you can. But the other thing you need to remember is SMCT is the highest SMC you can get. That's almost $9,000 a month. And that's for someone who has traumatic brain injury, and that leads them to exceptional need for aid and attendance. So you should be filing for regular aid and attendance and for SMCT. In addition, have you filed for, I don't know if it's for the Mr. or Mrs., but for erectile dysfunction, that's SMCK. That's one of the first ones. So those are the ones that I think that I would look at if I were you. Let's see. I was in the Navy and had 2 years remaining when the military sent me to an outside doctor for a sleep study. The results, I was told I have sleep apnea, but the VA denied me after the service. VA then gives me a sleep study and says I have sleep apnea. How do I fix this problem and get service connected for my sleep apnea? What I think that you need to do is, I don't know where the test was done, but if there's any way you can write and see if those records remain, you should also get statements from people who knew you at the time to say that you would fall asleep or you'd be sleepy during the day, or if it's someone like a spouse that you snored at night or you would wake up gasping for breath. So even though you don't have the test that proves it, if you had all the symptoms, then you can get a doctor to say, yes, you had sleep apnea during service. And remember, if it developed within a year of discharge, if you have a medical record right after service that shows you had sleep apnea within that year, that qualifies. All right. TBI keeps me from working and keeps me in bed for days and weeks at a time. My wife and aunt take a role of assisting me with daily living. I can't speak a lot of the time as a symptom. How do I file for SMCT? Does my case sound like it should win SMT? Yes, you definitely should file. You just need to say on the claim form, SMC-T, and then I would get very extensive statements from your wife and your aunt about all of the help that you need. Now, if you have a doctor, I would have them do a statement as well about all of the problems you need due to the TBI, traumatic brain injury. Remember, you can have problems, but if they're not related to a service-connected problem, or in this case, specifically to traumatic brain injury, it's not going to count toward that SMCT, okay? If you have service-connected problems that mean you need aid and attendance, then you could get that, but that's a lower rating. That's usually an SMCL. Like I said, that's around $4,000 and some dollars, where the SMCT is $9,000. So you need to be sure about what you're asking for And then when you have the witnesses talk about your problems, they need to limit it to the problems caused by the traumatic brain injury. Ivan, how do I file a claim for sleep issues? I have hip pain, arthritis, 10%. I toss and turn all night. I get about 4 to 6 hours of sleep, but burning pain, sometimes front of the legs and needles in my hands. I think that you file for, it sounds like it may be a type of depression, anxiety with sleep issues, secondary to, and that's what you need to put on the form, secondary to hip pain. Like it also sounds like that you should file for an increased rating for your hip pain as well. I filed a claim for my uncle, he's computer illiterate, for a tank accident that happened in the 70s. 3 weeks ago, he got an 80%. Last week, the VA sent a letter that he forgot to claim shoulder and mouth. Is that normal? No, that's not normal, but the law says, and it may be that on the compensation and pension exam, the person that did the exam said he should also file a claim for his shoulder and his mouth, because I think they also are service connected. So anytime that the VA sends you out to one of their doctors to do an evaluation and the doctor finds other issues that they think are service connected, the VA is required to tell you that, and then you should file a claim immediately. So that's a very good sign. This is Lee. The judge ordered that if I file for VA disability, I will be held in contempt of court. This was during my divorce proceedings. I was retired with permanent disability at the time of discharge, was found in contempt of court because of permanent discharge. I received 80% at the time of discharge and found to be in contempt in order to pay money to my ex-wife, and now ordered to pay what the VA military won't take out because of disability via manual payments. And despite further disabilities, which I no doubt be able to get, I will be found in contempt. You know, I have to tell you, I don't know how that works. That's the state court. I don't think the state has the right to do that. If you don't have any money, I would go to a public defender and ask them to help you with that. And maybe there's some free legal places, but this is a state court, it sounds like, and it sounds like they have absolutely no right to tell you to do that. Also, any money you get from the VA is supposed to be yours. Now, a court can also consider that in deciding what the award for child support should be. But no, this doesn't sound right. I'm living in Mexico. I'm 100% permanent and total with SMCL, aid and attendance, and I have an open appeal at the BVA. If I file for an increase or a higher level, would my claim be placed on long delayed regular lane? No. Remember, it's an electronic file, so you can file and pursue whatever you want that's different at the regional office while the BVA is holding your case and making a decision on another claim at the board. One of the problems that we found, and I want to make sure you know that, the statement of the case, so there are two ways to get to the board. The old system, Legacy, you filed a VA-9, and on there you had to say if you wanted a hearing or not. I am finding that almost every one of the VA-9s we filed, we don't ask for hearings. It slows up your case by years. So we never asked. We recently, I would say in May of this year, were given access online to see where our clients' cases are at the board. And I found almost every single one of them where we had not asked for a hearing noted we wanted a hearing. And this has been holding up these cases for years. So if you have a VA-9 that you filed and you've been waiting a long time and you did not ask for a hearing, you need to call the VA or send an email to the board and say, I did not ask for a hearing. I want to make sure that that's noted on my file. Now, if you're under the new system, the AMC, that's totally different because you either go directly up there, no hearing, no evidence, or you file evidence, that means no hearings, or you ask for a hearing. And so it's by checking one of the three that they have been doing that, and they've been very accurate, I think, in those. David, VA is finally doing a device-connected full knee replacement. Do I get 100% for a year? I don't have my book in front of me. I know you used to get 100% for a year. And then they usually drop you down to 30%. That's the minimum rating for when you've had a knee replacement. But remember, the year is, or whatever amount of time is, that's amount of time that they think it's going to take you to rehab. If your rehab is taking a lot longer, get a note from your doctor, and the 100% should be considered. The second thing you should think of is, unfortunately, sometimes knee replacements don't do the job, and people continue with pain or instability. If that's happened to you, then you will be entitled to a 60% rating. So don't take the 30% rating if the knee has not significantly improved. Michael, I fell at the hospital. I have a humerus fracture. Is there any recourse? I was attacked by a mockingbird. That's how I fell. Also, could I file a 1151 claim for my humerus? Yes and yes. I would file both. I think it's probably going to be 1151. And 1151 claims you can file for disability, or you can actually file a lawsuit. We don't handle the lawsuits, but the 1151 would be where you would show, but I think you're going to have to show there's some negligence on the part of the VA that caused that to happen. Whether they knew that there were birds flying around it, attacking people, or whatever that would be. Jody, I was wondering if you have seen alcoholism as a secondary approved more for bipolar or anxiety for vets that were retired by 1994. Yes, I have seen that, and I've seen it in a number of cases. So, so yes, I think that you could file for that, particularly if you have something that's called liver disease. So yes, I think that you could file for that, particularly if you have something that's called liver disease, which would be secondary to the alcoholism. Okay. So yes, I think that you could file for that, particularly if you have something which would be secondary to the alcoholism. Okay. Okay, I need those questions. Can you send them to me again? They disappeared. Okay, to which link? Okay, that's the one that caused the, how do you pause it? Okay, to which? Oops. I'm not techie, in case anybody thought I was. I'm not. So, okay, let's see if this works. Okay. I'm not techie, in case anybody thought I was. Okay, let's. All right, that paused it, and now let's. Okay. Okay, I'm trying to see where I was. Okay, R. Thompson, I have been waiting for 18 months for my supplemental claim. Is this normal? No, it is not. The VA, if they don't do your supplemental claim within a few months, you need to contact them and find out what's going on. A lot of times they will say that, a lot of times they haven't done anything because they've lost it. But other times what's happened is they say they've asked you to go to CMP exam. You never got any notice, and so they just closed your case. But other times, so I would call them right away. If you have a supplemental claim and you haven't heard anything, I would say by 5 or 6 months, you need to get with the VA. Marco, I had my comp and pen, and now the VA is requesting another exam. Is this normal? Yes, this can be normal. Sometimes you have an examiner who did not answer the questions that needed to be answered. Sometimes they brought up other questions that need to be answered. And we never know what it is until we actually look at the exam or we look at the request from the VA for that exam. Tony, in preparing for a PTSD CMP exam, I wanted to get a statement from my employer concerning my work performance. What would some key questions to ask them be to help me formulate their statement? Absenteeism, ability to get along with other people, problems at work, forgetting what you should know, forgetting to do things that you're supposed to do, anything that they have noticed that has kept you from being rated as a really good employee. And those letters are very important. I would say when you started working for them, when you stopped working for them, all of the problems they noticed with getting along with other people, coming in late, having to leave early, any of the things that they've noticed, I think that would be really helpful. And the other thing, if you're going to have a CMP exam, and this goes for any exam anybody has, get the DBQs. That's Disability Questionnaire, Disability Benefits Questionnaire. These are supposed to be online, okay? And they will tell you every question that's going to be asked you by the examiner or should be asked. So you should go through those to know what answer you're going to give them before you get in there, particularly for PTSD. PTSD is, the VA has amnesia. They have a list, and I always go over this with my clients. On page 4 of that DBQ questionnaire, it starts criteria, and it goes A, B, C, D, E, F. The VA feels that if you do not have something in each one of those criteria, A through F, H, G, whatever it ends in, that you do not have PTSD. So that's why it's very important to have the answers. I wouldn't take the form with me, but I would write your answers down. And then I would say, by the way, you didn't ask me about this, but I want to tell you, yes, I'm hypervigilant. I lock all the windows. I get up at night and make sure everything's locked and we're safe. I keep a gun in the house, whatever things that will go with that. One thing that I find a lot of clients ask for PTSD, or they ask for a particular problem. It is so much easier to get service connected for an acquired psychiatric condition. So if you have PTSD, it's your job to prove the stressors. In other words, what was the trauma that occurred that caused you to have this? If you have acquired psychiatric disorder, all you have to show is when you went in the service, you didn't have a mental problem. When you got out, you did. And you do this by statements from mothers, brothers, sisters, uncles, cousins, best friends, just saying, this is what I was like before. I had a great social life. I had lots of friends. I came back from the service. I didn't want to see anybody. I had an anger problem. I had a trust problem. I spent most of my time alone in the house. So think about that. If there's any question about proving the stressor, that's how the VA defeats you. So you need to be smarter than they are and figure out what to, because it can be bipolar, it can be PTSD, it can be depression, anything. It's an acquired psychiatric condition. And I find that the board is far more accepting of those than they are of PTSD where you can't prove it, or military sexual trauma. If you don't have great proof, try acquired psychiatric disorder. Okay, TJP. I was rated 100% permanent and total with a retro date of April 2019. And there is an older disability on my rating code sheet that shows as a non-static for RFE for this year, month, October, with no specific day. The disability was increased when I applied for it and submitted medical evidence, and they granted the increase. The letter stated there was chance for improvement. But after they granted the permanent and total, does it supersede any previous RFEs? This is confusing because normally it's one or the other. They either say there's a chance for improvement or they give you permanent and total. So I really don't know what happened here, but this is not normal at all. I would think that because they gave you permanent and total, that means they're not going to be permanent and total, by the way, doesn't mean that they don't have the right to come back later and evaluate you. Permanent total means they're not going to send you out for any more exams. So unless something happens, somebody calls up and say, hey, this guy's fine, he's working, gets along fine with everybody, and they do an investigation, permanent total means they're not going to be looking at you anymore. Plus, you get all the benefits you get with permanent total. I would guess, I don't know, I would guess that if they put permanent and total, then they may not put any follow-up exams for you, but I really can't tell from what you're saying. I would really need to see the paperwork. This is from Lee. DD-214 states permanent, have had numerous surgeries that easily able to claim, but will be found in contempt of, this is the, again, I don't know how this works. And I think that I would try to get a legal aid attorney to help me because it just doesn't sound right, but that's not, we don't go into the state courts, and this is a state court issue. This is from Robert. I was rated at 50% for sleep apnea, but not compensated. How is that possible? So Robert, I'm guessing, but what I think happened is you either had 100% already, and this extra 50% doesn't get up to the 60% for an SMC, or you may have had 70% for PTSD and a bunch of other things, and now this 50% leaves you at 100, where before you were paid at 100, but under unemployability. So in other words, what the VA does is whenever you get another rating, they combine it with your old ratings. And usually that's all they do. They're not going to help you to get SMC. So you need to get all of your ratings out and look and see if you think you meet where the SMC. So say you have 100% under unemployability. You have 70% for PTSD, but you're getting 100% for unemployability. If you get 50% for sleep apnea, you're not going to get anything because you don't have that extra 60%. One of the problems I find, though, is oftentimes, say you got 70% for PTSD, and then you get another 50%, and then something else. That adds up to 100%, a combined rating of a scheduler 100%. And often the VA will do that instead of giving you the SMC. And those are the things you should look at to see whether they should have given you the SMC instead of making you 100% scheduler. Now, of course, that means if you're 100% scheduler, you can work and get the 100%. If you have 100% under unemployability, you can't work. So you always need to think, which one is it that I would prefer to have? This one is from James. I have been diagnosed with gout and acid reflux. What can I claim it secondary to? PTSD, a mental problem. That's why you need to figure out what problems do you have that are service connected, and then you go PTSD and gout, or PTSD and GERD, and it will pull up in Google and show you if there is a connection. Now remember, you don't have to show that it absolutely caused that. You show that it's more likely than not that people who have, there's a greater chance with people who have PTSD that they will get GERD. That's the proof that you're looking for. This one is from David. Oh, I've already done that one. I watched a YouTube video saying, don't use 21-4138 because they don't look at it. Just wanted to see what you thought. I don't agree at all. The regional office will not look at it, but the board is bound by law to look at it. And a lot of times if the board denies you and they haven't really gone over these statements from you or from witnesses, that's an automatic remand from the court. So I think they're very important. And a lot of the judges at the board who are very thorough, the ones that are thorough, they're going to look at these statements and they're going to put a lot of importance on them at times. So yes, in each of my cases, if there's not a good statement already in there from the veteran or witness, I want it. Remember, if the board is going to turn you down, the regional office won't pay any attention. Forget about that. But you're making your case so that if you have to go to the board, you have good evidence to get them to award you your benefits. So the board, sometimes if there's just a statement from the veteran, then it's not going to work. But once you have a witness or two, then it becomes far more compelling to the board to put credence into what these people are saying. So no, I don't agree with that at all. But you need to know, everybody's different. Everybody uses, they feel like what works for them is different. This works for me. Eric, CMP exam stated that I did in fact have signs or symptoms attributable to non-surgical, non-infectious intestinal condition. Transient nausea accompanied with Montezuma's revenge in 2013. The question is, there's no question, but remember, if it's transient nausea, that means that it came, but it went. So what you have to show is you have a current diagnosis now. You have a current problem because of what happened in service. So I have PTSD and I'm currently depressed, angry. You can't say I had stressors, I had PTSD, but now it's gone. That's not going to get you any benefit. So you have to have a current diagnosis and symptoms of the problem. Bill, can I file a supplemental claim on one issue while at the same time as a higher level review for separate? Yes, that's one of the things that this does allow us, this new AMA program. So when you get a decision, if it's at the supplemental, you can decide to take one of the issues to the higher level. You can do one of the issues back at supplemental, or you could take one of the issues to the board. So yes, you have the right for any of those. And that's really hard to figure out what is we should be doing. This is a process we're learning right now. There's just, before you filed a notice of disagreement, period. Now there are so many innuendos in what we're doing. And, like I was telling you, if you did not have a high enough rating to get unemployability at the regional office, don't appeal that to the board. I thought we could appeal that. That's what we've done for years. Now I'm holding it and filing a supplemental claim until I get the high enough rating to get unemployability. But I have the claim pending so that they're not going to give me benefits effective the date that I finally, the effective date that I filed a new claim for unemployability. That supplemental claim keeps the appeal going. So you have to really, and I can tell you, I don't know the answer to all of this. I'm still trying to see what works best. And that's what you need to do. You need to figure out, do I have evidence for winning at the board? Do I have evidence to win at the higher level review? Now, remember, the higher level review is only going to look at exactly the same evidence that was before the person that made the supplemental decision. So if you brought in new evidence subsequent to the supplemental decision, you should file a supplemental appeal or you should go to the board. Going to the higher level, they will clearly tell you, I can't look at anything that you've sent in. Let's see, Rick, my claim for tinnitus is showing the status deferred. I have already been tested by an audiologist 6 months ago. Is it typical to wait this long? No. You need to send a letter. Is it typical? Yes. Should they be doing it? No. So you need to send a letter in, and you need to call the 800 number and say, what is going on with my claim? Or I'd send a status letter saying, what is the status of my claim? I had my C&P exam 6 months ago. Okay. Can I file secondary GERD and headaches to medications already service-connected PT? Yes. So this person is asking, I have major depressive disorder and MTSS. Yes, you can file secondary service connection for your GERD and your headaches. And you should do that right away. And remember, you want to not file just for headaches or for GERD. You want to show that they're secondary to these service-connected problems. Right. The VSO sent an appeal to the BVA without my consent. I have additional evidence and want to do supplemental. Do I cancel the BVA appeal and wait for that to clear up before I submit supplemental? Okay, so remember, you have a year to file an appeal. So if the supplemental claim was decided within the last year, you can withdraw the BVA. And I would say I'm withdrawing my BVA appeal so that I can proceed on my supplemental claim. If it's been over a year, you can't do that because then you're going to lose all the time that you've had. It's going to be like a new claim. If you have a secondary condition, do you need to be rated for primary conditions from which you think the secondary come from? Before you can get service connected for the secondary, yes, but don't wait because once again, you're going to be paid later than you should be for those. So I would file for service connected and for any secondary, but no, you won't be. And so that's why how you have to think about, if I'm denied at supplemental, do I file a higher level review or do I go to the board? You won't go to the board for anything that's a secondary if you haven't gotten service connected for the primary condition. So you need to think about keeping the secondary connections at the regional office until you get that rating for the primary condition. And that's what's really hard about this whole program. Before, what would happen is if you said I have a secondary service connection for headaches due to my mental condition, and you aren't service connected yet for the mental, the board would send the headaches down as inextricably intertwined with the question of the mental condition. Now they're not doing it. Now they're just denying it. So it's part of this new system that all of us are trying to figure out. What rules should apply when you have most criteria met for the next higher disability rating? Have a 10% for something that almost verbatim came. Okay, so if you have most of the symptoms for the next higher rating, you should be rated that. I think it's important to point all of those out. So you may want to do a 4138 statement. You may want to submit medical records from your doctor that notes these problems that you're having. I attended my CMP exam at QTC. Once QTC sent the exam results to the VA now says they need a medical opinion. I also submitted a nexus statement from the doctor. Is a medical opinion needed? Unfortunately, even though the law says if there is evidence to award the claim, I don't find the VA ever does that. So even though they might have a nexus statement from your doctor, they're going to send out for, I find what happens is when you put in good evidence, the VA automatically asks for a compensation and pension exam, and they call it assisting the veterans. I don't think it's assistant. I think it's a discovery to deny, but unfortunately that's what they do. Florida Marine. I filed a claim for sleep apnea secondary to my deviated septum and sinusitis, but the VA put it as a direct. How do I change it back to secondary? My first question is, if there's no chance that it was something that happened in the service, then I would just do a letter saying exactly what happened and make sure that they understand that. So one of the times where the higher level review is helpful is the VA says they have a duty to assist the veteran. The duty to assist would be in this situation. If they said, if they evaluated your claim as whether or not you had sleep apnea from service, that's not the claim you made. So what you would need to say is, there was a duty to assist error in that my claim for sleep apnea is secondary to my service-connected deviated septum and sinusitis. This was not evaluated, and I am asking that the duty to assist be complied with in this case. And in most cases, they will give you a new compensation and pension exam as to the specific question. Christopher, during a compensation and pension for knee, if I have painful motion on both flexion and extension, those are each 10 each. I don't remember exactly what it is, but I know you get a rating for both of those. Some cases you only get, like your back, if you're bending over, you only get a rating for whatever will give you the highest rating. Your knee is different. Your knee, if you have a problem with flexion, you get a rating. If it's extension, you can get a rating. I have recently been diagnosed with IBS, GERD, hypertension, urticaria skin condition, all of which my doctor says are related to my severe anxiety from PTSD. Should I file on 526 and a 4138? Okay, the 526 is the claim for benefits, and you do a 526 when you have never filed for these claims before. So since they're secondary to a service-connected problem, and you've never filed for them, I would use the 526. And I also use the 4138 to explain exactly what problems you have. I would not just say I have IBS, GERD, hypertension. I would say, or skin condition. I would say where the skin condition is, how much of my body it takes up. The same with IBS and GERD. Another thing for skin conditions are usually rated based on what % of the body they cover, okay? If you can get a color picture that really shows that, that's the best evidence you can send in. But you need to submit it on a 4138 statement, on a 4138 form, okay? Because otherwise they have a picture, but what is it? Is it your arm? Is it your back? And whose arm or back is it? So on the 4138, you should say, picture number 1 is a picture of me, and this is my back on this date. Picture number 2 is a picture of me on this date of my leg. So it's very clear what you're submitting. And that's the other thing with scars. People really lose the ability to get benefits for their scars. Scars are paid depending, are they unsightly? Anything on the face can give you a pretty high rating, but you have to, and I have found sending in a picture is the best evidence you can do. So you want color pictures that show it from the front, from the side, because you're looking at depression, or if it's, I forget the word, but it's higher than your regular skin is, or if it tears and it looks awful, or if it's made your face look deformed. Words don't describe that. Pictures are the best thing. So if you have a scar, it can be painful, but if it causes deformity or an unattractiveness on your face or areas of your body that are visible at all times, I would make sure that you do that with pictures. color pictures. You need to keep a picture color copy for yourself and a copy that you submit. And on the 4138, once again, you need to say who you are, when this was taken, and what area of the body it is. All right, a few more. Victor, is it hard to get compensation for severe sinus? If it's service connected, okay, I don't know, I'm assuming that it should be service connected, but the way that they rate it, I would get the book out because you have to show all of the symptoms, and I don't recall them right off, but I know a lot of them is that you're taking antibiotics or you're taking steroids, that it's an ongoing problem, or you've had to be hospitalized. So yes, you can get service connection for severe sinus, but you have to meet all of the criteria, and I didn't bring my book to go through those. Okay, Army George, I'm putting in for Social Security disability. I'm not working anymore and I have a bad back at 90%. Should I put VA disability paper in with my SSI application? So yes, I would. First of all, I'm making sure you file for unemployability from the VA as well as Social Security disability. And then I would say, I have a very bad back. It's rated at, it says 90% from the VA attached is the paperwork. This one from Michael does 100% TDIU, permanent and total. So TDIU is unemployability. Michael, permanent and total, get tax exemption benefits like normal 100% permanent and total. Yes. Last question, Brian, what is the official date for an intent to file? The VA letter says when they've received the intent to file. Where it says we've received your intent to file on X date, is that the official date? Yes. So that's why they send these letters. And it will say, we received your intent to file letter on March 1st, 2021. And that's your date. If there's a problem with it, then you need to write the VA and try to point out that you send it in before that time period. Okay, it's been a great time to talk with you all today, and I look forward to